Welcome to In Our Community, and thank you for joining us. I'm Joe Head, and we're going to have a fun time exploring maybe an arcane topic that isn't the usual kind of thing that you'd share cookies and iced tea over, or even maybe have a little wine with. Joining us as we begin to explore that what I'll call the mystery topic for right now is Tom Rossmeissl. Tom is a friend of mine from a number of years and is a local attorney specializing in estate planning. And that's our mystery topic we want to share with you this evening. Tom did his undergraduate work at the University of California at Davis, went on to Georgetown Law School, for his law degree, returned to California, and has been here in our area since then. Tom and I share an interest in Sharks hockey, among other things. But tonight and today, we want to talk about estate planning. So, Tom, why don't you lead us off, and what is estate planning?
Thank you, Joe. I'm happy to be here. So estate planning is really, what it comes down to is taking care of the family. And many people get confused about it or intimidated by estate planning, but it really covers about 3 different areas. Part of it is planning for what would happen in the event of incapacity. Who would you want to designate to be able to make financial decisions for you if you weren't able to make them for yourself? And who would you want to be making medical decisions for you if you couldn't make them for yourself? And if you have young children, if something were to happen to you and you were no longer able to raise them due to incapacity or death, who would you trust most to be the one to raise your children, to instill your values in them, and make sure that they grow up to be fine adults? And then the final aspect of estate planning is what most people think about it. It's how are your assets going to be transitioned after your death? Who do you want to receive those assets? And how do you want them to receive it? And do you want to leave a legacy? Is there charitable giving that you want to engage in? Are there groups that you want to support, whether it's community television or some other worthwhile organization that's important to you? And when you're looking into getting your estate plan prepared, there's several components that form what's typically known as an integrated estate plan. And that typically involves getting a revocable living trust, pour-over will, durable power of attorney for financial matters, an advanced health care directive, which is a power of attorney for making medical decisions, usually a nomination for conservator in case you do become incapacitated, and then if you have young kids, a nomination for guardian of the minors.
So let's take the young kids as kind of the last in that list of things you were talking about. If I'm recalling my time as concerned about young kids, which was a day or two ago, at the time the young kids were a concern, the bank account and the bill-paying systems were about in balance, but I wouldn't say there was any excess, and it was like, okay, we got this bill paid, and we'll pay next month's bills, and we'll make sure the mortgage is covered. But I wouldn't have said I was in much of an estate in that period of time. So let's assume I'm 35 and got three young children, all under 10. Am I somebody that should be thinking about estate planning?
Oh, absolutely. So starting with the kids, you've got the children that are under 18, and if something were to happen to you and to your spouse, you need to have a nomination in place so that someone you know and trust will be the person that would most likely be the ones to raise your children. Now, ultimately, that person is appointed by the court, but your nomination as to who you want to be the guardian for your children carries great weight.
So what happens if my wife and I don't do that?
Well, if you don't do that, then it's up to someone, and usually it'll be a family member, to step forward to petition the court to be the one to be named as the guardian, to then have legal authority to act on behalf of the child, to basically be the parent substitute. And if you haven't stated your preferences, then it might be competing family members or friends who all think that they should be the one to raise the children. And ultimately, the court would decide.
So in the kind of how we live here in Silicon Valley, frequently our families aren't with us here. They're somewhere else, in St. Louis or wherever they're at. Can estate planning take that into account? So my sister in St. Louis can get involved, and how does that work?
Yeah, so that certainly can be the case. And that's one of the topics to, excuse me, to cover with the clients when they're coming in to discuss estate planning. How old are the children now? Who would be the guardian? If the guardian is somebody that's out of state, that can be done. They would be appointed as guardian out in California, and then there would be a procedure, presumably, if your sister would take the children back to St. Louis and raise them there. If the children are a little bit older, sometimes the parents want the children to stay here and have a guardian that would come in from out of state, a family member, to live here and continue raising the children while they complete high school, for example. So it really can vary depending on the ages and the stages that the children are in, but it is possible to have an out-of-state person named who would then bring the children to their home state.
So we're thinking about who should be thinking about estate planning. Let's take kind of the other end of the spectrum. And I'm 75. My wife and I are 75. What are the issues that estate planning helps us to address, and how do you go about organizing that for me, the 75-year-old?
Okay, so on the 75-year-old side of things, you're typically no longer worried about minor children. But you are thinking more about planning for the distribution of your assets at your death. And you'd mentioned the 35-year-old with just the house and a couple of bank accounts. In California, it makes sense to have a plan in place regardless of what your assets are, because what you own has a title associated with it, and after you die, that has to be administered. It has to go somewhere. And depending on how title is held, it may go to the surviving spouse, it may go to your children, it may go to other relatives, depending on whether you have a plan in place or no plan at all. So in the 75-plus range, you're looking at, okay, I've accumulated the wealth that I have for my lifetime. I want to plan for what happens if I die first and I need to support my spouse for the rest of her life. What happens after we both die? How do I want my children or other family members or friends or organizations to receive that wealth? Is there one child that's needier than another? Is there one child that's fabulously successful and doesn't need any financial assistance, but you've got a child that's in a profession that perhaps isn't as lucrative? So maybe that child would need more from your estate, even if it's a modest estate. Now, we're very fortunate here in Silicon Valley that our homes are worth a lot of money. And that's a very valuable asset. So I'm concerned about my kids. Will they be able to have a home when they're out working, and can they afford to live here? But if I've got a home as part of my estate and I die and it passes on to my children, they have a home. And that's an important part of the planning.
So let's stick with the 75. I'm the 75 person. But, and I'm married. But my spouse and I, we're both in this is our second marriage. So it's not just the two of us. She has children, and I have children. And let's say that we don't have children together. We have, set families from a younger period. Mm-hmm. Can that be handled? Is that workable?
Absolutely. Yeah. And it's not all that uncommon. So we call it a blended family situation, where it's a second marriage or a third marriage, and there's children from the prior marriages. And what very typically happens is the married couple decides to have a joint plan together to hold their assets in a revocable trust together, but with provisions in it so that on the first death, that deceased spouse's share of the estate is put into a trust, and then the surviving spouse's share is put into a trust for the survivor. And you can structure it so that the survivor has access to the deceased spouse's trust to benefit the surviving spouse for the rest of his or her life. But then when the survivor dies, the deceased spouse's share can go to his children, and the surviving spouse's share can go to her children. That way you're kind of protecting both families, who will eventually get the assets coming to them from their biological parent. And depending on the ages and the assets in the mix, you could include provisions that on the first death, maybe that spouse's children get their share at that point. And you really have to balance what are the surviving spouse's needs, what are the financial needs to take care of that spouse for the rest of his or her life, while also preserving the ability to allow the deceased spouse's children to eventually inherit. That's a fairly common structure.
So there's a number of, I'd call them technical terms, okay, trusts and all that kind of thing. What about a phrase or a word that's more common to us, a will? And what is that, and how does that fit in with what we're talking about?
That's a good question. So a will is a document that you prepare. There's some formalities to it, but it basically says, after I die, I want my estate to be distributed however you choose, to go to my spouse, to go to my children, to make charitable donations, and I choose somebody who will be the executor of the estate. If you have a will, and if you have more than $150,000 in assets, that includes the home and bank accounts and all of your assets, then your estate will go through probate. And probate is the formal court process to administer an estate after someone dies. It tends to take a long time. Simple probate lasts anywhere from 12 to 18 months. It's fairly expensive. The fees that are set for the executor and for the attorney to administer the estate are set by statute according to the value of what gets probated. And it's public. So whatever happens through your estate is publicly known to anyone who's looking in the court files. Now, for most of us, that's probably not a big deal. But for example, Prince recently died and didn't have any estate planning. So his estate is going through probate in Minnesota, and it will all be a matter of public disclosure and probably public inquiry. Now, you can avoid that process by having what's called a living trust, or revocable living trust. And a trust is merely an agreement between you, the person who's putting your assets into a trust, the trustee, whose job is to manage those assets and follow the terms of the trust for the benefit of the beneficiaries. Now, while you're alive, you're typically all three of those people. You're the settlor, the person putting assets into the trust. You're the trustee of that trust, managing them for yourself, and you're the beneficiary while you're still alive. But the trust has provisions in it for after you die. It gives instructions to the trustee on what to do with those assets. Give them in equal shares to my children. So in that case, it acts like a will, how a traditional will would operate to distribute your estate through the terms of the trust. Excuse me. The benefit of that is any assets that are held in trust don't go through probate. The probate process, the probate administration, will only address assets that are not titled in the trust or that aren't governed by a beneficiary contract, like life insurance or a retirement plan that has a beneficiary designation, or that aren't held in a jointly titled manner that gives the surviving owner automatic rights to own the property.
So here in our area, how many people would have done some estate planning so that they don't have to go into probate and they don't have to get involved on all that? I mean, is estate planning pretty kind of everyday thing, or is it a little more exceptional?
So that's a good question. It really is pretty much an everyday occurrence, but it's surprising the number of people that don't do it. I was looking at some statistics recently, and nationwide, approximately 40%, less than 40% of Americans have an estate plan. I was really shocked to discover that less than 30% of adults with young children still in the home have any sort of estate plan, not even the nominations for guardian. I think there's a lot of misconceptions out there that I don't need an estate plan because I don't have an estate. I'm not rich, I'm not wealthy. But estate is just a legal term for property. So if you own a home, that's an estate. If you have a bank account, that's part of your estate. So any assets at all are part of your estate that may need to be administered after you're gone. And how simple that is or how complex it becomes really depends on the planning that you've done in your lifetime.
So how does someone reflect on or take an action to begin that good planning? Where do they go for information? And how do they kind of judge whether they're in the right direction and you know, on a good path to make some sensible judgments on what we're talking about?
Well, that's another good question, and there's a lot of resources out there. It really depends on the nature of the question or the issue that the people are interested in, because the estate planning covers so many broad areas. But the first good source of information is our friend the internet. You can Google anything these days and get information, and there's a lot of organizations locally that offer information about estate planning or offer ways to get in touch with an appropriate attorney that's got the right amount of skills and experience that could help someone and guide them through the process. So one of the best local resources, there's a couple of bar associations, which are the attorney organizations. There's the Silicon Valley Bar Association. That's a group of attorneys in Silicon Valley, counties in Silicon Valley that are primarily focused on trust and estate matters. There's the San Mateo County Bar Association. and the Palo Alto Bar Association. Each of those organizations is a good source of information, where to go to get more information. There are other organizations that offer information for seniors. SALA is, I believe it's the Senior Adult Legal Assistance group, and they offer legal assistance to elders, typically financially needy elders, but they're also a very good source of information on some of these issues. So finding those organizations and exploring, having powers of attorney in place, what does that mean? Gathering more information about living trusts and wills, and if the family's concerned about how to name guardians, all of that's out there. But one of the best sources, I think, is connecting with your friends and family who've already gone through this. So if you have a good friend that's had their estate plan prepared, there's a good source right away. Who did you use, and what was it like, and how do I get more information on that?
So what about people that are single, or maybe you've been divorced and not in any kind of relationship for quite a while, but basically people that are single people, kind of a growing demographic in the valley here. How does this affect them? And since it's not a shared, they don't have, let's say, children and spouse and that kind of thing.
Right, so single people need an estate plan too, for two reasons. Again, going back to the start of our talk, part of planning is planning for incapacity events. If I got injured, who would be there to make medical decisions for me? That's true whether I'm married or single. If I were to be injured and have say, an incapacitating event, I could no longer make financial decisions for me. I need someone there to be able to write checks for me, pay my bills, make sure that I'm taken care of, whether I'm single or married. And everybody who has any amount of property has the right to decide what happens to that when they're gone. What kind of legacy do I want to leave? Do I want to support the school that I got that great education from? Has my life been touched by cancer? Is there an organization that I can support to give back to the community and help people out that have done such good works in the community?
So I've had a good friend of mine recently had a kind of serious cardiac situation. Single man, and what you're saying is that's kind of a person is a good candidate for the kind of the planning and reflecting and thinking about. So when he goes to the hospital, does the hospital get concerned at all? Do his doctors get concerned? Does anyone get concerned, or is this just his activity?
Well, the doctors and the hospitals are all concerned primarily with the medical side of things. Does the person have what's called an advanced healthcare directive? It's a fancy phrase, but it's basically, do you have a document in place that authorizes someone to make medical decisions for you if you can't make them for yourself? Do you have a document in place that covers an end-of-life decision-making, as the pull-the-plug decision that people refer to? So it allows you to express your wishes that if you're in that end-of-life situation where you're expected to die in a relatively short period of time, do you want life support maintained? Do you want to be kept around, or would you prefer to be let go as gently and gracefully as possible? Now, what was it, 15 years ago or so, there was the Terry Schiavo case out of Florida, where a woman was being kept alive by medical science, and her husband said, she told me she didn't want to live like this, we should let her go. And the family said, you are not killing my daughter. And that went through the courts in Florida and went up to the U.S. Congress.
And she had nothing in writing specifically of what we're talking about?
Right. Had she had an advanced healthcare directive, a written statement by her expressing her wishes, there would have been no controversy. You follow those instructions.
And so, again, we'll stick with my friend, the single person. Do you share, and this might actually work for, come to think of it, for everybody, do you share with your family, your friends, kind of how you've looked at estate planning so that they're in on it too? Does that confuse the legal side of it, clarify the legal side of it, have no effect on the legal side of it?
It really has no effect on the legal side because the documents will control. But depending on the family dynamic, it may make a lot of sense to keep the family informed. On the advanced healthcare side, it definitely makes sense to let the family know what your wishes are. So if you want to be let go, the family should know that. Your document will say it, but it's easier on them to have that decision actually made and conveyed to the attending physician when you've told them that's your wish. On the other side of things, in terms of the other components of your estate plan, on how my estate will be divided up when I'm gone. Whether you tell the family that is much more personal, especially if there's going to be controversy. Now, if there is controversy, my strong preference is to advise clients it's better to have some transparency there, so to deal with that controversy now than to have it erupt after you're gone.
Yeah, because I think it's natural for us to not have conversations about serious illness, dying, death, the very kind of things we're talking about and are probably at the center of estate planning. So how do you help people overcome what I think is a very natural reluctance on our part to say, okay, well, that's it makes sense, but I'll do that the day after tomorrow, or maybe the day after, and so on.
That's a hard one, because a lot of people, I think, resist estate planning because these are difficult issues, and nobody wants to think about dying, and nobody wants to think about being so incapacitated from Alzheimer's or dementia or anything else, that, or it's just, it'll never happen to me. But it does, and accidents happen, and illnesses happen, and unexpected deaths happen. A colleague of mine just last week passed, 61 years old, a local trust attorney with no apparent health issue, and very unexpectedly passed. Because he was a trust attorney, I'm sure he had a good estate plan in place. But in terms of getting clients to address that issue, there's only so much you can do. And you can help guide them, talk about the issues with the individual client or with the married couple, but if it's not an issue they want to address, you can't force them to. You can sort of illustrate the consequences of not making that decision. And for example, with the healthcare directive, if you haven't made your decision on what would happen in that end-of-life scenario, then you've got a conflict. Your spouse would say, Joe wouldn't want to live like this, and the kids might say, you can't kill Dad, or the kids might disagree as to what's the appropriate thing to do. And then that gets resolved by the court if it's a big enough fight.
So in our valley, there's a variety of different cultures and persons and everything that add tremendous energy to our culture, but also gives people that are going to converse on this kind of a subject probably want to need to do it in a language they're really fluent in, and the subtleties and the differentiations in the language is important, and also how cultures approach this subject.
Right.
Are there resources that are readily identifiable for persons who would want to do this? Let's say their native language is Farsi, for instance, or whatever.
That's a very good question, and I'm not sure I'm the right one to answer it, but within the local community centers, there should be a wealth of information and resources available. And you're absolutely right. Due to cultural sensitivity and language issues, it makes perfect sense to be dealing with somebody in your native language on these very personal and private issues. Whether it's Mandarin speaking or Farsi or any other language, it's hard to be dealing with an attorney that's only speaking English on these very delicate and difficult matters.
I can think of a number of communities of people who would have, even as, let's say, the 75-year-old, we'll take that, the example again, will have relatively little affluence to think about distributing, but have an interconnected network of family responsibilities that needs settlement or decision-making. The estate planning would assist in that also, I assume. So that if I'm, and also I wanted to ask is, can material things, homes and everything, that are not here in the U.S., they might be in Mexico or Canada or France, or India or China, is international activity possible for estate planning?
It is, and it can get very complex at that point. And it's not uncommon at all for people living here in Silicon Valley to have assets overseas, whether it's in Europe or Asia. And it's very important, especially if there's real property involved, to make sure that your U.S.-based estate plan is coordinated with a plan that works in that country. The fact that you've got a U.S. revocable living trust doesn't mean it will have any effect on property held in France or in India. And what I generally recommend to my clients facing this is that we coordinate with an attorney in that jurisdiction to make sure that the assets there are managed and held and titled in a way that coordinates with the U.S. plan to make sure that the assets ultimately go where you want them to go. And sometimes it's family-owned property in India that's going to stay with and co-owned in India with a bunch of family members in India, and that's fine. You just need to coordinate what your U.S. plan says with the plan appropriate there.
When we have intergenerational families here, where it may be a local family that are U.S. citizens and parents living with someone who are non-U.S. citizens. Again, that same discussion taking place. A good idea for that same discussion to take place.
Oh, absolutely. And if there's multi-generational wealth transfers occurring, especially with significant wealth overseas that might be coming to the U.S., it can get very complex, and there can be a lot of tax implications as well. And at that point, if there is the multi-generational family mix, it's very important to seek out good quality legal advisors and tax advisors to make sure that your plan for how the wealth will continue to be held in the family is done in an appropriate way, and that the tax implications of the overseas assets and U.S. citizenship or non-U.S. citizenship are taken into account, because there can be completely unexpected results when the tax man comes.
Yeah. College-age students, especially if they're attending college beyond the local area. Good idea, or is it a little early for that?
Good idea for two of the instruments. Everybody that's an adult should have the durable financial power of attorney, so if something happens to me, I've got somebody named who can act on my behalf. And same thing for the medical power of attorney, the Advanced Healthcare Directive. If something happens to me and I can't make decisions for myself, I've named someone who can make them for me. Okay. Now, for the kids in college, they may not have real estate to worry about passing on to the next generation, but those two instruments should be part of their plan.
Okay. I want to thank you very much for being with us. It can be a complicated, tough subject. It's a really worthwhile thing for you to do. I can tell you from my own personal family experience, it's a good thing for a family to go through. Our children and our grandchildren have participated with us and have an idea of what we will all be doing when a serious illness would confront anyone. Thanks very much for joining us.
Thank you.
In our community.